All my life, I have held a certain idea of Columbia Arbitration Day. Both instinct and reason have led me to it. In my view, Columbia Arbitration Day can truly not be Columbia Arbitration Day without a sense of grandeur. Ladies and gentlemen, some of you will have recognized the words of the great Général Charles de Gaulle. Because yes, I am absolutely certain that this is more or less what he might have said had he been with us today. And indeed, speaking of grandeur, I now have the privilege of introducing Yas Banifatemi, Sabina Sacco, Reinisch, and Carolyn Lamm. The task, however, is no easy one. How does one capture in just a few words such rich and distinguished careers? From co-leading alongside Emmanuel Gaillard, one of the world's foremost arbitration practices at Sherman and Sterling, to founding what has become one of the leading firms in the field of arbitration for Professor Banifatemi. From working at White & Case and Levy Kaufman Kohler before establishing her own arbitration practice for Sabina Sacco. From being described as one of White & Case's most well-known names in international arbitration to being appointed by President Clinton to the US panel and later by the government of Uzbekistan to its ICSID panel of arbitrators for Carolyn Lamm, from receiving the Austrian Cross of Honors for Science and Art, first class, one of the highest distinctions for scientific or artistic achievement, to heading the section of International Law and International Relations at the University of Vienna from Professor Reinisch. Grandeur is certainly not something you all lack. And yet, three of you have one flaw. A flaw that might, in other circumstances, have been disqualifying. Three of you are teaching at Harvard, the University of Miami, the University of Vienna. What about Columbia? Professor Bermann, I hope you can make something.
I heard that.
Fortunately, you are not teaching at NYU, so we are forgiving you. So please join me in welcoming Yas Banifatemi, Sabina Sacco, Reinisch, and Carolyn Lamm.
Thank you, Charles. There's one qualification one has to have to be in this fireside chat, which is to be a friend. And these are four of my best of friends. Thank you for joining us. This conference probably wouldn't be complete if we didn't at some point introspect, which we haven't been doing that much about. We've been talking about geopolitical catastrophes of the European Union and all kinds of more or less extrinsic things. But my colleagues were very interested, and I think rightly, and let's look at what we're doing as arbitrators. Let's see how we're doing as arbitrators. And I think that's necessary alongside everything else that we've done. Now, three of the speakers are going to be talking about matters that flow into one another very strongly. So the divisions are artificial, I would say. So don't feel bound. I think there'll be a lot of simply, ideas floating among you. Sabina is going to talk about something I consider very important. And let me just, by way of introduction, say what it is. International arbitration, we're told, allows for out-of-the-box thinking about how disputes should be resolved. And yet, I think we'll agree, to a very large extent, not completely, international arbitration has become somewhat procedurally standardized. Now, there may be differences of view about that, but that's how I see more standardized than it would need to be. So something I think Sabina responded to, if I'm not mistaken, was the idea that tribunals might be more inventive than they have been, and that may or may not entail proactivity. Now, he's going to be followed by Yas, who is it's a closely related issue, which are what are the current procedural due process issues, what are the requirements, what are the challenges associated with due process. And August is going to talk about, of course, when and how are we going to overcome the expense in time and cost. Now, I hope you see how those three are really closely related. So that will be a very fluid conversation. Now Carolyn indulged me because maybe because I'm somewhat an academic, I maintain an interest in issue conflicts. And Carolyn has had experience on this subject, so we're going to have that at the end. So that's what I anticipate of our group. And the three of you should really feel free to comment on each other's propositions. Okay? So Sabina, inventiveness. I'm sitting with Sabina now, and I've seen inventiveness, but you can still address it.
Thank you, George. Thank you very much. Before addressing this fascinating topic, I first want to thank George and the entire Columbia Arbitration Day team for inviting me to speak at this fireside chat. As opposed to many of you, I've only known George a few years.
3 years.
We are sitting, as he mentioned, in a very complex case, but that has been enough time to grasp the extent of his intellectual lucidity, humanity, and integrity. So thank you, George. So the short answer to your question, George, is yes. I do think that international arbitration calls for more procedural inventiveness. As we know, party autonomy is one of the key features of arbitration. When it comes to procedure, the parties are, and the tribunal are bound by very few rules, some mandatory rules of the seat, and certain basic rules set out by the relevant arbitration rules. But other than that, party autonomy can be given free rein. Once when I was talking to a non-arbitration lawyer friend of mine, and I explained this to him, he exclaimed in surprise, "All is fair in love, war, and arbitration." And I think he has a point. And yet, as George has correctly noted, in recent decades, international arbitration procedure has become quite standardized. Parties and arbitrators are tending to apply what some legal authorities have referred to as a uniform code of arbitration, which has been influenced, as we heard yesterday, by common law more than the civil law. And most arbitrations will proceed in the following manner. You will start with a case management conference. We will then have one round of submissions. Then we'll have a document production phase, a second round of submissions, a hearing, post-hearing briefs, costs, award. And in most arbitrations, parties, at least the ones I have participated in, the parties have been keen to be bound, well, guided, let's say, by the IBA rules on the taking of evidence. Arbitrators, such as myself, will tend to apply our own models and templates in order to get things going smoothly and without much time spent. And so I have to say that I don't think this is necessarily a bad thing. There are benefits to standardization. One of them is procedural certainty. There is comfort in the familiar, in knowing what to expect and how to do it. Counsel have learned the ropes, and proceedings can proceed smoothly. These templates are said also to reflect best practices. They have been refined through time and now reflect what we hope works best. And of course, there's also no need to reinvent the wheel. I mean, there's a reason why these models have survived, and they can be easily adapted. But I think that there can always be room for improvement. It's important to tailor proceedings to the needs of the specific case and making sure that the interests at stake are addressed. And I think that to some extent, and I include myself here, we have become complacent, and we tend to ignore opportunities for the proceedings to be more effective. Now, note that I speak here of effectiveness. I'm not speaking of efficiency. August will deal with that issue. Efficiency, in my view, refers to managing time and cost so that you don't devote too many resources unnecessarily. Effectiveness, however, refers to tailoring the proceedings in order to obtain a better result. But what is the desired result? And here is where, in my view, things get more complicated. Because I think that the stakeholders in arbitration have different interests that are not always aligned. And when I speak of stakeholders here, I'm going to refer broadly to the parties and counsel on one side, and the tribunal on the other. And I know that parties and counsel can also have different interests, but for the sake of simplicity, let's keep them together. And so, in my view, there's two broad groups of interests. And some interests are related to process, procedure, more technically, and there are interests related to outcome. By process-related interests, I'm referring to the parties and the tribunal's desire for the arbitration to proceed smoothly and efficiently. And I think it's safe to say that these interests are usually generally aligned. We all want the proceedings to proceed smoothly and efficiently. But there's also what I would call outcome-related interests. And here is, I think, where interests diverge. The party's interest is to win their case, to set forth to the tribunal their case in the best possible manner. The tribunal's interest is to rule on the case and to find out the truth, or at least the procedural truth. And this, I have to say, I found has not always been aligned. So let's take them one at a time. How can we be procedurally inventive in order to ensure process-related interests? Here, I think it's not. I think we can be better served by starting with the tried and true standardized procedures that we have come to know, and attempting to tailor them to the needs of the case. I don't think we need to start from scratch. It would probably be more efficient to start with initial discussions in a case management conference between the tribunal and the parties, and set out procedural rules that are relatively standard, but I think here's where it's important to tailor them. My practice, at least, is to ask the parties before we start setting up the procedure whether they envisage 2 rounds or only 1, or whether they envisage having document production or not, whether they envisage a hearing or not. And here, when it comes to the specifics, we can find relatively, I would say, simple ways of making life easier for everyone. And let's take one example, which is document production. It was suggested yesterday that we could do away with it. That, however, I think might go against one of the parties' interests, so it would not fall within my simpler process-related group. But we can certainly make document production easier for all of the users. And for instance, we've seen how with the Redfern schedule, the Redfern schedule was one of the first ways of trying to simplify. Then that became unwieldy, and Professor Stern suggested the Stern schedule, which put the different document requests in a vertical table. Then Juan Fernandez Armesto came up with a different one, which is called the Armesto schedule, in his honor, of course, in which he had a table in which he envisaged everything fitting into one page. I have personally adopted a version of Juan Armesto's schedule, although it does not fit in one page. But the important thing here is that we can try to tailor things so that they make it easier for both the parties and the tribunal to rule on the specific issues involved. Now, these procedural tools are likely to be well received by the parties because they are still aligned with the parties' interests. However, what happens when interests are not aligned? As I mentioned before, the tribunal's interest is to understand the case and to be able to rule on it efficiently. the party's interest is to win, and I don't think that that necessarily helps, that those interests are not always aligned in what you want to see in the proceedings. And let me give 3 examples here. Experts. Experts are supposed to assist the tribunal in issues that require expertise. Yet tribunals find themselves routinely confronted with opposing experts appointed by the parties. When both experts seem competent and reliable, how is the tribunal to choose the right answer? So Klaus Sachs attempted some years ago to bridge this opposition with his proposal of the Sachs Protocol, which proposed the creation of an expert team appointed from a pool of candidates, proposed by both parties, but ultimately reporting to the tribunal. But as far as I'm aware, the Sachs Protocol has not been used very often. Why? The answer, in my view, is simple. It's because the parties want to be in control of what experts they choose and to work with them to present their case in the best way they wish to present it. Another example, the hearing. I think I'm not alone in feeling that many times hearings can be a waste of time and resources. So much money spent to organize it, so much time consumed in cross-examining witnesses and experts. But many times the tribunal walks away without having learned anything particularly relevant. In a 5-day hearing, usually a single day is spent on party arguments, which can actually be quite useful. And 4 full days are spent cross-examining witnesses in ways that are not always useful to the tribunal. Why? Well, I think it's because counsel, and here my colleagues who act more as counsel will be able to tell me their opinion, I think it's because counsel want to obtain certain answers, which in their view might destroy the credibility of an expert or witness or reveal a smoking gun. But smoking guns are rare, and tribunal members can usually see through aggressive cross-examination tactics, especially when this relates to experts. A third example, the post-hearing phase. Once the hearing has been conducted, the parties, and let me say here also the institutions, magically expect that the discussion of the case is over. And I heard yesterday Professor Smith mention that by the time that we get to the hearing, it's too late to discuss certain issues. And I think he has a point there, which I will address later. But the reality is that the hearing opens up new issues. For instance, when the tribunal asks questions that point to new issues that had not been addressed before, or point to an elephant in the room that nobody had wanted to address. And so then we need to spend part of the post-hearing phase dealing with these issues. Then there's quantum issues, which sometimes require complicated procedures. The case that George and I have been sitting on, the quantum phase, has taken us 2 years. Depending on the case, you might need to work with joint valuation models, and this might take a significant amount of time. So, how do we address these conflicting interests? I think that here's where we need to make sure that when we use procedural inventiveness, we are addressing the needs of both the parties and the tribunal. So, I just want to finalize by giving 3 potential solutions for the issues that I just highlighted. Experts. I doubt that we will be turning to tribunal appointed experts anytime soon. I was reading, when I was reading up for this presentation, I saw one legal authority refer to them as the Loch Ness Monster, often talked about but never seen. I thought that was a very apt description. But what can we do with experts? We can try to narrow down the issues before the hearing. One solution that comes to mind is, instead of having 2 rounds of expert reports, why don't we have 1, and then ask the experts to meet, confer, try to find issues of agreement and disagreement, and then submit a joint report explaining where they agree and where they disagree, so that by the time we get to the hearing, it's a bit clearer to the tribunal what are the disputed issues. The hearing. Here, I think that there's 2 things that we can do with the hearing. The first is to try to find a way to turn it into an opportunity to narrow down issues. How do we do this? And here I want to turn to a proposal made by Neil Kaplan, which is the Kaplan opening. What Neil Kaplan suggested, first he pointed to the fallacy that the tribunal is capable of processing all and holding all of the thousands of pages that have been submitted before getting to the hearing. Yes, the tribunal will dutifully read everything before getting there, but there is nothing like having the parties presented to you in a concise fashion with their oral arguments, assisted by well-drafted presentations. And so his idea, which I have to say I find extremely wise, is to hold a preliminary hearing only to deal with opening arguments. This preliminary hearing will allow the tribunal, and here this would have to be organized in tandem. You could have a day of argument, a day of deliberation, and then a day of closing. I wouldn't want to call them closing arguments, but a case management conference with the parties in order to narrow down issues in dispute before the tribunal, to propose any questions or areas where they need more evidence or more argument. And here is where we could address those issues, Professor Smith, that would otherwise then delay the proceedings. And so by then, we could then potentially give the opportunity to further submissions if needed, and then we could get to the merits hearing, or we could really call it now an evidentiary hearing, and deal with only with the examination of witnesses. But how do we do, here's my second point on the hearing, how do we make these examinations be more useful to the tribunal without curtailing the parties' rights to address whatever points they want to make? And here I think that one idea would be to ask the parties who have submitted the witness to identify what issues each witness, what facts that witness is supposed to support, and what is the relevance of that particular witness, so that by the time the tribunal could receive this, and then when each party calls each other's witnesses for examination, the tribunal could then have a better idea of what is expected and possibly tell the parties what it wants to hear from each witness. And finally, this is my final point, I also want to talk about the cross-examination of legal experts. I have found it increasingly frustrating to sit at the cross-examination of a legal expert, itching to ask questions that I cannot ask or do not want to ask in order not to interrupt counsel's train of thought. But the fact remains that the tribunal wants to hear the expert say what he has to say without necessarily going through the tactics of cross-examination. And I'm wondering, with respect to legal experts, perhaps we should allow the tribunal to go first. Let the tribunal ask what it wants to ask. And then let the parties come in and ask whatever they want to ask without restriction. And maybe that way they also can know what is interesting, they can realize what interests the tribunal and tailor their questions accordingly. So with that, those few proposals, I now open the floor to my colleagues for their comments.
Wonderful. Sabina, just a word or two, and then I want to hear from Yas and August and Carolyn. There is sort of a theme, I think, that emerged from your suggestions. I just felt as you went through everything, things were getting better defined. Each of your proposals struck me as better definition of what's at stake, whether it's having the experts confer, whether every one of yours. I don't know if you would think of that as a leitmotif, but I think what I want to point out is that you haven't been driven by efficiency considerations, and I'm sure August will have something to say about this. Some of your proposals have efficiency advantages. I think maybe some don't, and that would be very interesting to hear August on at some point. And I think, Yas, you have a lot to tell us about procedural due process, But we could put every one of Sabina's prescriptions under the microscope, and we could ask, are there due process implications to any of them? Now let's have including Carolyn, of course, let's have a little conversation about these proposals without preempting what you both want to say. Next.
Shall I?
Yes.
Thank you, George. 3 comments. And I love your presentation, Sabina. There's a lot actually to unpack. My first comment goes to what you just said. Well defined. There's a lot of proposals that help a better definition of what's at stake. But that's because Sabina is an arbitrator who works her cases.
Yeah.
Who, just the proposal of being the first to ask questions before the parties cross-examining the experts, that assumes that you know your case, that you've worked, you go to the hearing knowing what the experts are saying, and so on. Sadly, that's not the case every time, and we know tribunals that do not work their case. So efficiency and effectivity also comes from that, arbitrators doing their work, and that's the expectation, number 1, I guess, from arbitrators when we appoint them. That's my first comment. The second comment is going to, before even we ask the question of inventiveness, which I love to be inventive, I love to, think outside the box. It's great when we can. But again, isn't the first assumption to do, and that's related to my first and my third point, to do what the parties expect. And so there's a responsibility also to not drive the parties to an expectation of full standardization and for them not to establish a procedure that is responding to their case, to their needs, to the needs of the case, and so on. So I'm happy when I hear Sabina say that she will ask at the outset from the parties what they do want. And I'm surprised these days to have an arbitrator who comes and says, do you want document production? Maybe not. And that actually was one of my first ICSID cases where and that's the responsibility of the institutions as well. In my early ICSID cases, I received a procedural order draft from the institution, and it had document production. And I resisted that. And I went to the parties and I said, do you want document production? They had not thought about it. And when I asked the question, they thought, and they came back and said, actually, no. So, of course, I'm not deprived of my power to order documents if I want as an arbitrator, but it's also for the party to determine what they want. And that's more cost-effective, that's more efficient, and to some extent also more effective. So it's a question also of taking our responsibilities as arbitrators and taking our responsibilities as counsel to drive the procedure in a way that responds to the needs of the case. And then the third point goes to expectation of the parties. I've had a recent case where we had international parties from both sides, but with an English law applicable and a London seat. And the tribunal's expectation became, oh, this is an English case, we're going to apply CPR. And notwithstanding outrage from one of the parties and the fact that this is an international arbitration, it's not an English litigation, and so on. And the procedure was conducted based on CPR. And that is really something that arbitrators should avoid, which is, it's not their expectation we're talking about, it's the expectation of the parties. And really listening to the parties and then responding to what they think is good for the case and for their best interest, and conducting that on that basis.
Yas, I think there's a real synergy between what you're saying and what Sabina is saying, because the more inventiveness you bring to the enterprise, the more you can ask the parties about. The more things you think about, the things you've said, we could now ask the parties about those things they may not ever have thought about. So I think we can combine inventiveness and responsiveness to party preferences. I think that would give us big dividends. August?
If I may jump in at this stage, exactly, and Sabrina and we had some discussion. It's very difficult to distinguish between efficiency on the one hand and inventiveness, because why do we want to be inventive? In order to be more efficient, of course, and I closely followed her. So some of that overlaps, and I hesitate a little bit to produce now my conclusions, but I will for the sake of our discussion. So case management, early check on the expectations of the parties, as Yas just put it right now. Also the question of the efficiency of the hearing. I listened very carefully. I liked some of the detailed and very granular suggestions that you made about maybe a tribunal asking first before you have the lawyers for 2 days asking their questions and everyone is exhausted to continue here. Now,
just to clarify, only for the legal experts.
No, of course, the legal experts. Yeah, no, of course.
I'm not sure I could do that with the technical.
And actually, I think it's exactly the questions, legal experts not only, and the damages experts in particular. You mentioned that. The question of damages often in many of the investment cases are addressed in so many hypotheticals. Hypotheticals, what do I mean? Depending on whether liability is found, on what ground it is found. So I have become a big fan of bifurcating not just jurisdictional issues, but in particular thinking about reserving damages for a later phase in the arbitration once you find whether there is liability or not. Because what we currently see in many of the quantum expert reports is a whole range of possible calculations that remain speculative until the time that you find that there is a liability. And once the tribunal reaches that in an ordinary case, hearing everything, or at least hearing liability and quantum at the same stage, it may become very difficult. So that would certainly also contribute to more efficiency. And I think I should keep a few other efficiency recommendations for another round.
Okay. Carolyn.
I just have a few observations, very limited. Number one, I never like efficiency at the price of due process. Parties have to feel they've been heard. And, you know, one of the great impediments of arbitration, of course, is you have no compulsive power as a tribunal to order the production of documents, whether or not a party hides them or doesn't hide them. There are a lot of procedural issues that I think are very important in an arbitration that I wouldn't want to cast by the side unless it is an arbitration that is small enough or easy enough that you don't need to do it, but consulting the parties, of course. In terms of the questioning of experts, I think both. I am always concerned about the issue that Yas raised, whether the arbitrators have really read everything. Part of that falls to the parties when they let experts put in 250-page opinions that no one would read. But I think, of course, that if you have a decent submission, you've had a glimpse at what the law and the damages arguments are in the opening. You then have the experts who testify for 30 minutes up front. I welcome the tribunal's questions. If they start in the beginning, if they start in the middle, I always want to hear what are they thinking, what concerns them, so I can address it. Because in all of this innovative approach, what we can't abandon is the significance of party autonomy, the party's ability to make their case, whatever they think it is. And I have no problem with the tribunal saying to the parties, you know, that's not terribly persuasive, the way you're raising it. Think about X or Y. But I do have a problem with being absolutely cut off on something that I think is fundamental before the tribunal has heard enough of the case. I mean, that impairs the party's ability to make its case, in my view.
Sabina, anything you want to add with respect to what you've just heard?
No, I just want to say I fully agree with Carolyn, because, I mean, the arbitrators, I think that we also have to put ourselves in the shoes of the people here. The arbitrators are reading what you present, but there's only so much that you can grasp in your head without having been working on it day and night, as counsel have. And maybe counsel are in a better position to point to us what is relevant. But I think that it's important that the tribunal understands it, and in order, you need to get through to the tribunal. And I think that this is where we need to find a solution that allows the parties to make their case and the tribunals to really hear it. And that's where the inventiveness, that's the goal, I think, in the inventiveness.
Well, inventiveness isn't a term that we have commonly used when we try to think about improvement of arbitration, and I think you've concretized it very greatly. I want to give one example which is not at all novel, and it's not inventive on my part, but it's just one of those things that I have found has made, in some cases, arbitration more effective, and that is the use of expert determination. Now, there's a lot to be said about that, but I think I've told my students, I think they've heard this. I've been in a couple of cases where I am convinced that there was value not only in efficiency, but in accuracy. By having committed to experts, in one case it was a single expert agreed to by the parties. In another case it was 3 experts. Now they're not legal experts, I hope that's clear. I'm talking about meteorological or mineralogical experts. And in the cases where I've had that, and I'm curious to know whether, to what extent you have, I am confident that they did a better, not necessarily quicker, but a better fact-finding of technical issues. I've been in IP cases where I'm over my head. I'm completely over my head in those cases. I wonder what my colleagues think about that. I don't think it's used. It's not a complete rarity, but it's not used that much. And I'd be curious to know what your experience has been, or whether you think I'm going down the wrong path here. Yas, have you had this?
I have, and not very successful in my experience, I'm sorry to say. Because you may have issues of just appointing the expert, whether that's the right profile, and
Yeah.
you know, sometimes there's a requirement in the contract, and you have to go through the motion, and again, to some extent, at the end of the day, it's a decision by the tribunal, and the tribunal will have to understand
No
the
question.
issues.
It's just that we're provided the factual basis for our exercise of legal judgment.
Exactly.
Yeah.
Yeah, but in my experience, I've not been, not really.
Maybe I'm just too easily pleased.
I don't know.
I don't know.
It depends on the case and the difficulty and complexity of the issues.
Yeah,
Like that.
I've had good results. Carolyn, on this, expert determinations, have you made use of them?
I know.
Okay.
I must say, I don't like when you turn to the experts and say, okay, talk among yourselves and give us your report. It's as much as I've found, a giant waste of time and money, because they rarely come back with a beautifully refined set of things. They just find a way to write the controversies. I don't know that a single expert, not selected by the parties, even if they're selected by the parties, is going to be as good as having the two experts, where the tribunals are smart. They can listen to the expert opinions and discern their views and ask questions. I don't think it's as
Maybe
good.
I can give you an example of one of them that I thought was profitable, and this is the one I've used in the classroom. We had a case of a ruptured, very big, serious ruptured pipeline. And the question, there was a lot of questions about the rupture. What did the rupture consist of? Where were the aspects of the pipeline? Where were they located that could have caused the problem? I thought we got really good technical input that I would have been hard-pressed, even listening to experts, to evaluate. Now, I realize there's a degree of delegation. It's a degree of delegation going on there, right, Carolyn? And that's maybe what you're concerned about. But I'm willing to tolerate that when I think the factual issues are ones that are just better addressed in a different phase. Now, it's not time-saving because we have an expert determination phase, and then we get a report, and then we move on to merits issues. And it may take longer, and it may be undesirable from an efficiency point of view. But I'm trying to build on, Sabina, if I understood you correctly, that there are sort of non-efficiency considerations, non-efficiency considerations that enter. Maybe it's accuracy, maybe it's better definition. I thought we had a better define, that's my preoccupation, better definition. But that's just been my experience. Have you, Sabina? It's not that common.
I've never had an expert determination, no. I would be...
The parties agreed on, I have to be clear. It wasn't imposed by the tribunal. I should be clear, Carolyn. This was what the council wanted.
Both parties. Both
yes,
parties.
Both parties.
If
now,
both
of course,
parties
party
agree.
autonomy is at work. But what I like is the idea that party autonomy is being employed creatively. You know? So, August, you too? Never?
I also didn't have that experience, but I think it sounds very plausible. And I think our concerns would be significantly lowered if you tell us that it's party agreed.
Well, Carolyn, I really misspoke when I didn't make it clear that this was coming from the parties.
If it's from the parties, then I agree.
But I want the parties to be inventive also.
Yeah.
You know, I want counsel to be inventive. And sometimes you can stimulate that. No? Now, let's hear about yeah.
Can I just come in on that idea? Because you mentioned just now that it might not be good for efficiency because it might be an additional phase. I'm not so sure. Because if you have that determination, it may then make the rest of the proceeding more efficient. So
I think you're right. I've not studied the comparative efficiency. I've not approached it from an efficiency point of view, to be quite honest. No? Carolyn?
Well, it seems there would be quite a lot of deliberation about what you showed this expert.
Yes, of course. Yes. No, it's not a simple matter.
It's not a simple matter. Yeah.
But I just want to be on record saying I've had success, and there may be those cases where it's apt.
If I may add one point, and I agree with Carolyn that to the extent that the parties would agree, it's a different matter. Now, having said that, as arbitrator, I would have a bit of reluctance to feel bound by someone else's determination. I would probably feel more comfortable having a tribunal assisting expert to rely on if I have difficulty with a truly very complex technical matter. And then it remains my duty and my responsibility as an arbitrator rather than relying on somebody else's
Well, we
determination.
just need to keep being inventive. So what we're going to do is have counsel have an opportunity to question the authors of the expert opinion. And I mean, I just think we need to be nimble, you know. I don't know if there are any further thoughts, but that, I don't want to dwell on expert opinions. It's simply something I found out of the box in my experience and apt. Now, August, let's put efficiency on the table. In and of itself, even knowing that there are efficiency implications of what Sabina had to say, just as there may be due process implications. But let's talk about efficiency on its own terms, if that's okay.
Absolutely. I'd love to. But before I do so, I should say that I'm very grateful to the invitation. This is my first appearance at the Columbia Arbitration Days. For some reason, they always take place while we have the Wismut in Vienna. I'm sure it's a coincidence, but it is a prohibitive one for some of us. This year, of course, I could not resist. Unlike most of you, George and I, we don't know each other that long. I had the pleasure to sit under his chairmanship on a very interesting case. A very interesting case also, and that reminds me of something we discussed yesterday. How are we accountable as arbitrators? You remember the debate we had here? And I found very interesting, there was some talk whether AI would check our outcome or whatever. But somebody mentioned, no, the real accountability is in our co-arbitrators and the way how we discuss and how we try to come to a reasonable outcome. And under the fabulous guidance we had from you, I think that's exactly what happened. And at the same time, it also was an example of we could disagree on some points. I think that's very important, especially if in the field of investment arbitration, we all know there are so many contentious points. There are no right, correct, and incorrect decisions. There is maybe a slowly growing prevalent majority view. But until that time, we may be able to disagree. Now that, in a very different context, came back to me very recently when I was involved in a set-aside proceeding before a national court. And one of the issues raised there is exactly, should the court de novo review jurisdiction, or should it give some leeway to where reasonable persons can reasonably disagree, especially, and that was one of those cases where we have a still rather inconsistent case law on whether jurisdictional requirements are fulfilled. So I think that that is something which is very important and what I appreciate in the art of arbitration, so to say, to come to these conclusions and to try to come in from every kind of perspective, trying to find a correct outcome. Well, whatever correct is. We had also interesting discussions. I prefer the Ancestral Working Group 3 terminology talking about consistency. Yes, not correctness, but that's aside. Now, the topic is efficiency. And again, linking that to some of the other topics that we heard yesterday, would artificial intelligence help us to be more efficient? And we heard interesting proposals, and at the same time, quite some doubts whether it would really work. Maybe summarizing party submissions, maybe summarizing the facts, but then we know we still have to double check how much efficiency is gained by that. Now, it inspired me to do something what I usually don't do and what I'm actually not very good at doing. I ask artificial intelligence, how do you make investor-state dispute settlement more efficient? Now, I'm not very experienced with that. And what struck me most, that yesterday's answer was slightly different from today's answer. So artificial intelligence apparently doesn't only hallucinate, it also evolves very quickly. That was the first thing. The second, and I won't to keep you too long, but I'll read the one paragraph which I got yesterday. It also shows immediately that it's not really that much intelligence. It's a large language model. It reproduces what it hears. And the more it hears it, the more likely it will reproduce it. And maybe some of what is reproduced is AI generated in turn. So the short answer, or the chapeau of the answer, how to be more efficient, was making the investor-state dispute settlement system more efficient involves a mix of structural overhauls and procedural refinements. Current reform efforts, largely led by UNCITRAL's Working Group 3, focus on reducing costs, shortening timelines, and ensuring more consistent legal outcomes. And then follows a long list of what's called structural reforms, procedural, operational efficiency, and state-level preparation. I don't have the time to go into all these details, but what I found so interesting is that apparently because of the way a mass of literature is produced under the title of efficiency and reform, suddenly the system generating the answer for me cannot really distinguish between what is really efficiency and what is maybe some other goal that is going to be pursued. More consistent legal outcomes, and the first answer is establishment of a multilateral investment court, a standing appellate mechanism. Now, we had a very interesting discussion yesterday, which I don't want to repeat here. Clearly, if we want to have more consistent outcomes, a form of appeal is a tool that's useful, but we all know it's going to take longer. It's not producing a fast one-step outcome, and it may be actually in conflict with the goal of efficiency. I'm also not quite sure whether the so-called plurilateral interpretive statements, so the idea that has found its way in a number of more recent BITs, that the contracting parties should authoritatively interpret the meaning of some of the terms in bilateral investment treaties, certainly reassertion of control of the states, that's clear. It may also lead to a correction of some of the interpretations given by arbitral tribunals. But why should that contribute to efficiency? I remember, I think, when the first NAFTA interpretation came out, the tribunal was struggling whether this conforms to due process. If one of the parties to the dispute, gets the two other parties to the treaty to support it in interpreting the treaty. So all kinds of issues are raised in this context. Mandatory mediation, one of the suggestions before arbitration. Now, med-arb, any kind of coordination of having first some form of amicable dispute settlement, and from the investment arbitration field, we are well aware of that. I do remember a couple of years ago, I think some arbitral tribunal talked about amicable dispute settlement periods as being nonsensical. Now, that's an extreme view, I agree. But does it really help to solve a dispute if you prescribe the parties 6, 12, maybe 24 months to try to find an amicable solution. I mean, if they want, if they are interested, then they will do so. And they are always free to engage in settlement discussions during arbitration. But whether that increases efficiency, also very questionable. And therefore, to me, also a kind of irritating result, how far from intelligence and how close to just reproducing language we are when we try to get some support by these means. Now, I don't want to go into details, rather, and I know our time is up sooner than we wanted, I would like to come back to the convergence with Sabrina's suggestions on more efficiency. And I mentioned already that I would also welcome maybe more tribunal direction. I think arbitrators could use giving more direction to the parties, ideally persuading the parties, not imposing on the parties what the tribunal wants to hear and from how many experts, etc., etc. So that would be something that's helpful. I mentioned already the question of bifurcation, trifurcation, and I know that's also a very difficult one. It may appear almost counterintuitive to say, let's have different phases. It seems to create a longer procedure, but I think that need not be the case. It could lead, with a tight schedule, to a much more focused form of dealing with the problems that are brought to the tribunal, that have to be decided by the tribunal. As a civil lawyer, I know when I came to study here, and I'm glad to see that Charles left. I have to confess, I got my LLM at NYU still. I was teaching here 2 years ago, so I hope this kind of is a form of atonement that I did. No, but seriously, when I came here, the most mysterious thing was document production. I had a chance to work in a law firm, and at the time, literally, there was this windowless room with hundreds of boxes, and a lot of the documents were German in a litigation, so they asked me to go through, and I just couldn't believe, what is this whole exercise? Now, you get used to it, you actually get to like it, but controlled. So it certainly sometimes has become too much of a burden, not only for the parties, also for the tribunals. Let me close. I think one point that arbitrators rarely talk about, but is an important one, is self-discipline. We should not overcommit ourselves. Whether it's teaching classes, George, you know how it is. It's a lot of work we have to do for university, whether it's other cases, whatever. Making sure that we have the time in order to deal efficiently with the cases that have been brought before us. And yeah, this is something where I can only appeal to each of us to make sure, because I have been sitting as an arbitrator in cases where after 2 years we started to deliberate, and yes, you need another week or two in order to make sure that you get back into all of this. So that would be maybe a theoretically easy point to live up to.
In the interest of time, let's turn to due process. We can circle back to efficiency, but I want to leave time for issue conflict. So let's see how due process factors in here. You can either, as you wish, address the address the due process implications of what have been said, or just your own thoughts about where due process needs to take us?
Thank you, George. I will start by thanking you to having invited me here. It's both a pleasure and honor to be here, to celebrate your 50th year of presence in this institution. It's amazing. I'm in awe. And I am part of those who have not had the benefit of your teaching. So I'm not a former student, but we're friends. And we've been, for years, we've been debating. We've had our differences. We have points of agreement. And it's been fun, George. It's really been fun.
It's been fun. And we disagree a lot. And friendship survives.
And exactly, that's true friendship. So thank you for having me here today.
Sure.
I want to address the famous question, and encouraged by George to do that. You all know about that famous question at the end of the hearing when the tribunal asks whether, and you have a number of different varieties of the question, have the parties any comment on the way that this arbitration was conducted? Do the parties have any due process issues that they want to raise? You can be as broad as possible, as benign as possible, but you can also ask a very specific question. And I want to take an example.
Good.
Which is from a case, actually, in the US, from the District Court of Columbia, I think. And that's in Chicago breach case. And the question was asked by Juan Fernandez Armesto. Quote, is there any breach of due process rights which the tribunal has committed and which any of the parties would like to draw our attention to, and so that we can take the appropriate corrective action? Can I get the confirmation from you that you don't have any issue of due process which you would like to raise to our attention? I mean, he goes quite far and really encouraging the parties to come with whether or not there were any issues and what corrective action.
And to stop them.
Exactly.
Right?
Exactly. So that's the famous question. We're all used to it. And I want just to break down, I don't want to be too long. I want to break down into a number of different features of the question. And different features of what, who, how, when, and why. So what is it that the tribunal is interested in or that the parties raise? Depending on the rules and the arbitration laws that may be applicable, you have a question of non-compliance with the rules or the arbitration agreement or tribunal orders, and that you find generally in the rules on CITRO, ICSID, and in the law of Singapore, which is a model law. You have also a matter of irregularity, that's the French model, or rules of procedure in Switzerland, or improper conduct in the UK. So you name it, but the fact of the matter is that it's a broad definition of defects in the procedure and the way that the arbitration was conducted, because at the end of the day, a setting aside judge or an enforcement judge will look at the integrity of the process and determine whether there were procedural defects. And it can be due process, but it can be more than that. It can be, for example, the existence of a conflict by an arbitrator that was not brought to the party's attention. So this is broad. Who? Who has to act? Well, it's normally the parties. If you look at the rules, if you look at the arbitration laws, it's the party that has to bring an issue forward if they have an issue of due process or any type of irregularity. And if they don't, they have waived the right to object. So the burden is on the party. The question is how then? So that means that if it's the party having the burden, it's the party that has to raise the issue, whatever it is, in time. And if not having raised the issue, having the risk of a waiver of the right to object. So then why do we talk about the tribunal? And the famous question, it's not the burden on the tribunal. But the way that the tribunals do it is simply that they want to shield their, of course, they want to shield their ward of challenges, future challenges, and they want to make sure, depending on the way that the arbitration was conducted, to give a chance to the party to raise issues or to remedy it, but for sure to make sure that they're protected at the time of challenge before the setting aside or enforcement judge. When? Well, generally speaking, it's as soon as possible, as soon as you get to know of the issue. So, and then again, you have a number of varieties in the rules and arbitration laws. UNCITRAL and ICSID rules say promptly. The French arbitration law says in a timely manner. It's a bit more reasonable. Timely manner, what does that mean? The English Arbitration Act says forthwith.
Immediately.
Means literally.
Immediately.
Literally, right there. Some arbitration laws, Swiss law and English law, refer to a duty of the party to exercise due diligence in the way that they know or should have known of the issue and to exercise reasonable diligence. And some certain rules or laws are a bit more tricky. The ICC rules in English law, they don't give it time, they don't say promptly, but they say you should not proceed without having raised the objection. So it's a matter of, again, reasonableness and the way that the judges look at this. You have to raise it in time, but you don't have mandatory time as promptly or forthwith and so forth. Well, actually, in English law, you do forthwith. The last question is why? Of course, it's a matter of exercising your right to object and to preserve the right to object to the award, the outcome of the arbitration, if there's a defect. And you haven't, and that's unanimous in all of the rules and the laws, it's that you waive your right to object. Certain rules, certain laws do provide specifically for a justification and specific circumstances that prevented you from knowing and from raising the objection, but when you do not have that requirement, the case law generally follows and says, well, I'm going to look at whether or not there were justifications for not knowing or not raising. That is, well, justifications specifically provided in the French law on arbitration, in ICSID and UNCITRAL rules. So then, and that's where I want to finish and really put it out for discussion, is what type of conduct to expect from both the parties and the arbitrators. From the party, is it enough to raise a reservation of rights? Is it enough to say, oh, I'm not happy with the way that you conducted your proceeding and I reserve my rights? And that's a tricky question because when it's raised by the tribunal, the famous question, if the arbitration went smoothly and there were no incidents and there was nothing and everybody was perfectly civilized, it's easy to say, yes, thank you, and everything was wonderful, thank you very much, and you move on. But let's assume you have a real difficulty. You have issues of due process. You have issues that you know, fought about. It's extremely awkward for the party and counsel to say, I'm not happy with what you did, and here's why. And you may or may not set it out fully, but you still have to set it out because you saw it, you know, the rules and the arbitration laws require you to do that. If not, you have waived your right to object. So that's really the tricky position for counsel, which is how far do you go? Is it enough to reserve your right, or do you go beyond? And likewise, depending on the rules that apply, for the tribunal, what's the expectation? Should the tribunal say, okay, I've noted your objection, I will take it into account and I render my word on that basis. Is that enough? Not really. Depending really on the type of objection that's raised, you may have to go beyond. And the way that the laws and the rules are set out is really to give a chance to the tribunal to remedy. And so I have a few examples. And it's really on a case-by-case analysis. You have the Swiss law, and the Swiss law specifically says that you have to give the tribunal a chance to remedy. In Singapore, it's interesting. And I want to refer to a case which is from 2021 from the High Court in the Kaj matter. And it's pretty harsh on the party, but presumably justifiably so. And I quote, this would ordinarily require that the complaining party at the very least seek to suspend the proceedings until the breach has been satisfactorily remedied, if indeed the breach is capable of remedy, so that the tribunal and the non-complaining party has the opportunity to consider the position. And then later on, the decision says, if a party chooses to carry on in such circumstances, it does so at its own peril. The courts must not allow parties to hedge against an adverse result in the arbitration in this way. And you have the same language from the English High Court. And I have the example of ASM Shipping in 2005. That's one of the landmark decisions. And I quote, they, being the owners, one of the parties in the arbitration, could not get themselves into a position whereby if the award was in their favor, they would drop their objection but make it in the event that the award went against them. A heads we win and tails you lose position is not permissible in law, as Section 73 makes clear. The threat of objection cannot be held over the head of the tribunal until they made their decision and could be seen as an attempt to put unfair and undue pressure upon them. So this really, and you see that it depends on the way that courts, and you have strict review from the Singapore and the English courts as to how you make the objection and how far you go, is to require some type of remedy. So in the French Court of, Paris Court of Appeal decision of February 26, quite recent, the Paris Court of Appeal refused to set aside, saying that, well, what was required is to ask for the opportunity to actually put forward a separate submission, and that would have taken care of the matter. You have another case before the French Paris Court of Appeal, which is, well, if the arbitrator did not disclose a potential conflict and that was not known to the party, therefore the party was not in a position to promptly react, and therefore you can't set aside the award on that basis. So it really depends on the type of irregularity and what the party could do and what the tribunal could do in terms of remedying the situation. The question, the big question is what if you can, and I want to put it out there for thoughts, what if you have, as party, brought the position forward, you have reserved your right, and tribunal continues to conduct a proceeding in a way that that party considers to be in breach of its due process rights. And it continues to do so. And at the end of the hearing, with the famous question, says, well, no, I'm not happy. You've not conducted this proceeding fairly, and my due process rights have been breached. What is the remedy then? Do you ask the tribunal to start over? Do you want to have a stay? And the Singapore court has referred to a stay. It's too late. Do you start over the arbitration? So that's it's tricky. And then so you have reserved your right. You have done what you need to do, but at the end of the day, if it's against you, what happens? So I want to put it out there as a question, and so that was...
okay, what I'm going to suggest is that, because in the interest of time, I want to ask all three arbitrators who are on the stage what your immediate reaction is to that. I will tell you, the last time I was not chair, the last time the question was raised by the chair, counsel said, I prefer not to answer. I prefer not to answer whether or not I have procedural objections. That's also an option.
Well, that's an option. Well, when it becomes tricky, that's the easy way out for counsel. But in the case with Juan Armesto before the courts in this country, counsel said, no, I don't have any comments, right? And the court took that as, well, you lose. You didn't make your, you make your case on irregularity, right? Yeah. So then the question is that even enough?
Yeah. Okay, well, let's quickly hear about that. I just want to say the first time I experienced it, I felt very uncomfortable. I felt very uncomfortable putting counsel under that kind of pressure. But I want to hear what Sabina, August, Carolyn, is it tempting to you to?
Well, I have seen it done. I was a secretary to two famous arbitrators who shall remain unnamed, but you all know who they are, for many years, and they do, it was their practice to ask this question. And so I took the practice myself, but I have to admit that I feel very uncomfortable asking the question. And I have asked myself whether it matters if I ask it or not, because as you have rightly said, it's on the parties to raise any objections. If they have not done so, they have waived their objections. And if the objections arise from the hearing itself, maybe it's too soon to ask them, to ask the question. I mean, I would tend to think that it really doesn't matter if I ask the question or not. If they have an objection, they will make it, whether I ask the question or not. And then it falls to whoever's determining, the judge or the institution, if there's a challenge, to decide if we did right or wrong. But I do think that it's on the parties to raise it to the tribunal first. I mean, if they think that there is a violation of due process, the tribunal should be given the opportunity to correct it.
August, your views, your preferences?
Well, in that sense, I was wondering, you said too soon, maybe it's too late. It could go either way, and I share your concern. I mean, it has become kind of a ritual of arbitration, yes, and we all know it may also work as a shield for the arbitral panel. Now, having listened to Yas, maybe we shouldn't ask the question anymore, I feel. Because it's very convincingly, it doesn't really matter. Because if there was a serious violation, that should not preempt the parties of raising it. And if there was no problem, what's the point asking?
The real problem is the scenario you raised where there is no waiver, there is an objection, okay, and it's overruled. Now, there could be a due process. It hasn't been waived, right? I mean, that's the common scenario. Carolyn?
Well, I have to answer as counsel most of the time. You know, I must say, when I'm asked that question at the end of a long hearing, I sidestep it and I will say, well, you're well familiar with all of the letters and objections I've raised, and you've dealt with them the way you chose to deal with them. Yes, I seem to recall one annulment proceeding where we were opponents, and she, in fact, played back to the annulment panel my sidestepped question.
Oh, well, this is a really interesting, we all have reactions to this. I don't think I'll ever get resigned to doing this sort of thing, partly because I don't think it's useful. And I think it's unfair. But there you go. Carolyn, let's just change gears completely.
Okay.
Okay. And let's all of a sudden talk about issue conflicts.
Issue conflicts. Well, first, I do want to thank you, George, for inviting me. And I came because of your years of tremendous work for the American Law Institute, leading the restatement for 12 years. Now, certainly we've had a few controversies during that time, but you did such a fabulous job, and I thought he asked me to come and do one little thing, even though I'm in a hearing. I'm
going to have to take responsibility for this, because if it weren't for you, there would not have been that restatement. You had an uphill battle.
I had an
uphill battle getting the ALI to commission this restatement. They said, we don't need it, it's federal law and it's statutory.
That's right. They said, we don't need it. I finally argued and argued and argued, and I saw Lance here the other day, and he was convinced. And the others on the council were convinced, and we were so pleased to have not only George, but Jack, and just a wonderful group of reporters that brought it home. So putting that aside, I did want to make a few remarks about issue conflicts. They are so tremendously difficult, and I must say I've looked at them sitting on an arbitral panel where one of my co-arbitrators was in fact objected to. I've challenged arbitrators and argued that that an award should be set aside because of a non-disclosed conflict. And I've certainly been challenged on panels. So it gives me a relatively broad and somewhat pragmatic view in looking at this. And I think it highlights what is a central paradox in selecting arbitrators. We all want experts. We want experienced people who, in fact, have thought deeply, have spoken, have really engaged in scholarly debate, and you have some idea that here's a person who is analytically careful and strong, etc. Should that really disqualify someone from sitting as an arbitrator? Does it so impair impartiality that that person is ill-suited to decide a case? I think it requires a careful balance between party autonomy, selecting the arbitrator that they choose as best to decide a particular dispute, and the question of, is the person impartial, and will they look at the case through an impartial lens? And I think it's a very granular analysis. At the end of the day, we have a scope of consent that relies on having impartial arbitrators who are independent decide your dispute. And that is, to me, a fairly fundamental consent question. And I think just because someone has written an article, argued a case, or given a speech about a certain theory, it doesn't mean that that's the way the person will decide a case presented to them. I mean, you listen to the advocates, and the good advocates will say, yeah, I saw you wrote that article, and here's why this is different. This is what we're asking you here. And you're also discounting the input of the other two arbitrators on the tribunal. There isn't a tribunal that I've ever been on where they just said, okay, all right, if that's what you think. That doesn't happen. There is enough back and forth as on the law, on the facts, and I think it is quite important when you look at the standard in terms of the existence of an actual, or here's the tough part, apparent bias on the part of the arbitrator, stemming from previously expressed views. Now, I know, George, you've expressed at the UNCITRAL working group, and I think in your classes, a view, Ray, and it's really been very formative in the views on this and the jurisprudence on this in terms of impartiality, independence, and appearance. And that is so hard to assess and to be sure that you're not, shooting ghosts under beds. It is not something that should be disqualifying. There must really be, to challenge someone, a predisposition where they appear to have totally prejudged an issue. And so it has to be fairly specific and not just a general observation. Most recently, and this is curious, a case out of the PCA, the Lufthansa versus Venezuela, where we just saw the decision on March 20th, where Kaj Hobér was challenged for sitting as an arbitrator in that dispute. Venezuela alleged that Kaj failed to disclose that he was co-counsel in a case before the Swedish Supreme Court that involved an MFN clause. Under a different bit, it had gone to award, so this was an appeal. Ultimately, the Secretary General, now this is interesting, did disqualify him, but he said, well, he was unpersuaded that Kaj had prejudged the MFN issues because they were not coextensive and didn't, in fact, address the same legal concept. But he disqualified him, and he disqualified him because he failed to disclose the Swedish case, and the Secretary General said, and I'm still trying to tease this apart, there was a tangible risk of overlap. But he declined to, in fact, decide it on the basis of a prejudgment. I don't know how you you separate those two concepts. I think the most interesting, and it was published in some of the papers I think we saw for today, is the ICSID Code of Conduct in the background papers, where they summarize all the various different kinds of issue conflicts you might find. Prior decisions, multiple appointments, academic writings, and we find cases going both ways. It really requires a very granular analysis of the facts with respect to the alleged conflict and exactly what one is being called upon to decide. So, and we, of course, have the IBA Orange List, where, you know, it is always an issue to examine on public advocacy, public statements, how specific are you? But my general observations are, you have to analyze the specificity of the precise legal issue where there's an alleged issue conflict. You look at the repetition, you look at the, you know, pattern of advocacy, how strong are the statements, the manner of expression, how specific is it? Is it enough that you can say the person was absolutely predisposed? And the one that I always find the most telling is non-disclosure. You ought to disclose it. If there's anything at the outset, either the parties or the institution can raise. So thanks.
Thank you. Am I being told that no questions? Oh, we can continue.
10
Wonderful.
Minutes. 10 minutes.
Okay. Any comments on this first? You do? Yas?
Happy to. Two comments. Fully agreed with Carolyn. Maybe two comments. On MFN, it's really interesting the way that they dealt with this Kaj Hobér issue. It's you know, it has to be very specific. I have my own experience with this because I did write an article on the MFN clause, and at the time, I remember, it's a while ago, I remember people saying to me, "You're nuts. Why'd you do this?"
I had the same thing on MFN.
Exactly.
They said, "You're nuts."
"You're nuts. Why'd you do that? You're not going to be appointed." And I said, well, if I'm going to write an article, I'm going to say what I think, otherwise why write? It so happens that in a matter as arbitrator, the MFN came up, and I disclosed. I said, these are my publications, and the parties said, okay, we'll think about it, no problem. And then exactly as Carolyn says, in a case where I was sitting with August, actually, the MFN clause came up, and then the tribunal refused to give effect because simply of the way that the treaty was drafted.
Yeah.
So it depends on, you know, it's not a generic question that has a response for every single situation. So fully agreed with Carolyn. And the second comment I will make is that I remember when this question arose in the early 2000s, and I was invited in Madrid at the IBA to discuss about this, and I was very much in a minority, taking the point of view that Carolyn was taking and saying, you know, why make it such a difficult, high threshold issue? My issue with it is that, especially in a world where we have more and more professional arbitrators, if you are going to be afraid of speaking your mind and making a decision because next time you're going to be challenged because of a decision you made for bias or apparent bias, then we end up having arbitrators who will not decide and arbitrators have to decide as a matter of law. So what is this world where we're going to go with arbitrators being split the baby all the time, in being in the middle, not actually taking position on the toughest questions of law, and that's what we want them to do. So in terms of conduct, I think it's truly problematic. I'll stop there.
And in fact, these challenges don't have a high success rate. The very strong presumption that the arbitrator's mind is open. And very often it's put that way. Is it a closed mind or an open mind? And there's a very strong temptation to say of a respectable arbitrator that he or she still has an open mind. But there are the rare cases. Any comments on that before we go to the audience, if we can?
Well,
Sabina?
I just want to say that I find issue conflicts extremely difficult, and I fully agree that there is a chilling effect of telling arbitrators that they cannot rule in a specific way, or that they cannot write scholarly articles in a particular direction. I think that we expect arbitrators, especially when they're academics, to have a position on issues. And I think there's something to be said about the proposition that in investor-state arbitration, we have to expect, I don't want to say a lack of impartiality on the side of our party-appointed of investor-appointed or state-appointed arbitrators, but you have to come to expect that they will have a particular position on issues of law, and I don't think that necessarily amounts to impartiality, but we are trying to, the idea is to appoint people who know what they're talking about, and they will have a position. So yes, that was my only comment. I cannot comment on the Lufthansa case because I am actually chairing it, so.
August, any last words on this?
Not a last word, just two very quick observations which actually go in different directions. One is, and I agree with Yas, of course you can distinguish MFN, there may be specifics, and it's this MFN clause and that the MFN clause, etc. But on the other hand, we know many arbitrators, many academics have certain positions that may be relevant. So we cannot just talk away a potential issue that may arise where there's a likelihood, and also the parties may have selected arbitrators having in mind that could be the position. On the other hand, and this is what always strikes me in this whole debate, if you go to a judge, has anyone had an issue with a judge having a firm position on a legal matter? Maybe there are some jurisdictions where that is the case, but I'm wondering whether we are applying the correct yardstick if we demand arbitrators from being free from issue conflicts and having no problems that there are the tough and the lenient judges or whatsoever.
Thank you, August. Now, I don't know, Charles? A couple of questions? 5 minutes. Well, you may forget what we've spent most of our time talking about, which was efficiency, inventiveness, and due process, and of course issue conflicts. So we have time for some questions. Please, just identify yourself.
Hi, I'm Mauricio Garcia. I'm a 1L here at Columbia. My question is, so on the issue of efficiency, what do you think about arbitrators hiring more secretaries or something analogous to clerks as what a judge would have to increase efficiency and being able to deal with more cases, you know, taking your expertise, but also being able to handle more cases? Thank you.
Can I take that one? Well, I'm all for it. And I'm going to start by saying that that's how I started my arbitrator career, being a secretary. So I think that there's many benefits to having assistance when you work as an arbitrator, I don't think, especially with the amount of pages that are submitted to you, it is impossible for arbitrators these days to deal with everything on their own. So I think that having tribunal secretaries is really something that can help with the efficiency of the procedures. But of course, you cannot delegate any decision-making functions, and the tribunal must always have control and know the file themselves. But I do think it's a great way to foster efficiency of particular proceedings and also to create and train new arbitrators. Because it's the best way, I think, to learn how to be one is to work with one.
Sabina, I'd like you to, if you don't mind, I'd like you to even imagine the possibility of not having a secretary in our current case. You know, it's inconceivable.
There are cases where it's inconceivable. I think obviously it depends on the case, but I do think that it always helps. And I don't think that there's any law firm. I don't know how Carolyn would survive without a team. And I don't know how a Supreme Court judge would survive without some help with his clerks. So I don't see why we shouldn't apply the same rationale to arbitrators.
Any other comments here? No? Okay, good. Other questions or comments? Please.
Hello, Andrew Hashem from A&O Sherman. Hi, Professor Bermann. I was a former student, by the way. So I had one comment and one question. One is a comment on the point raised by Madame Banifatemi on the question that is asked at the end of hearings. And it seems to me that, I can see the point of asking the question if you're an arbitrator, but there's also certain due process violations that only become apparent, in my opinion, once the award is rendered. So for example, something that I'm thinking about is a reversal of the burden of proof, that you would only find out whether that due process violation actually happened at the time in which the award is rendered. So I'm not sure that the question would necessarily help in that particular situation. And then that's just my comment, my general observation. The question that I had, and this actually gets to an area of interest of Professor Bermann's. It's a twilight issue question. And it seems to me, and it is still on this due process point, and it's a question for all of you, because you've all been arbitrators. And in a situation, and a twilight issue in general is sort of an issue where the question of the governing law of answering that issue is unclear, if I'm just going to summarize it. So if I'm in an arbitration in front of you and I raise a due process violation objection in front of you, there's multiple ways in which you could maybe handle that question, but there seems to me a question of what law would govern the answer to that question, right? Because I could have a New York law governed contract, I could be seated in Paris, and potentially the enforcement of this award is going to happen somewhere else. And a question of a violation, for example, of the right to be heard could be that you could have a different answer depending on the law that you choose to apply to the answer to the question. So I'm just wondering, how would you deal with that? How do you deal with that, or how would you deal with that if I'm raising a due process violation?
Comments? Question?
You want to start?
No, I would say that in principle, I would consider a violation of due process to be a procedural issue. So then I would focus on looking at it from the viewpoint of the law of the seat, because it's the lex arbitri that governs the procedure, the mandatory rules of the lex arbitri, and it is also the courts of the seat who will review any challenge to the award. Of course, enforcement could take place anywhere, but that's how I would start.
I think you have to look at the rules that applied, and you have the language in the rules. So you are conducting a proceeding based on those rules. To the extent that the law of the seat is relevant, you may also refer to the law of the seat. But there I would like to refer everyone to the writings of Professor George and the legal theory of arbitration and the role of the seat. and whether or not you're a monolocalist and really focusing on the law of the seat, or if you have a transnational view of arbitration. And I think that due process is certainly, and if you look at, well, the guide on the New York Convention that was drafted by Professor George and Professor Bermann for UNCITRAL, it really looks at due process as a matter of, and procedural due process as a matter of public policy. And that's something that's common to all systems. So if you look at it from a transnational perspective, a breach of due process normally would undermine the award, whatever you look at it. So you don't necessarily need to look at the law of the seat, but you can also look at it from a transnational perspective in public policy, in procedural public policy, if it's truly a question of, a major concern of due process. One word on your comment, I agree. So there may be the outlier on the circumstance that you learn of when the award has been rendered. By definition, that's something you did not know and were not supposed to know when the issue arose. And then normally, if you go to the courts, relevant courts, enforcement or setting aside, then you may have a case to make in that regard.
This question, you may remember, arose in the restatement, but it was with respect to what the court's approach should be. And there was a discussion about whether it should be the law of the seat or whether we should adopt a transnational standard. And I must say, I forget what we did, Jack, but I think this is ripe for transnational standard. Myself. Not that it may be easy to come up with what that standard is, but I'm not sure we should be bound by what particularities a given jurisdiction associates with due process. They can be very idiosyncratic, and I think we want to avoid that. So I'm with Emmanuel on this. I really am. But people disagree. Time for one more, perhaps? If any? Am I missing any hands? No. Okay, there's a hand. Okay. Obviously, what I want you to do is to thank this brilliant panel for a wide-ranging discussion.
Yeah, thank you so much all.